Well, I thank all the county officials who provide us with all the great material. I'm here today with Addie Rooker. She's sitting in the back of the room. Addie's one of our consultants at Wagner, Winchell and Associates. Been with us since 2001 and works as kind of a HR person for hire, if you will, with a couple other people that do the same thing in other counties. But over the years, our firm has been engaged by over 60 Indiana counties. Most of the work we do is in the development of personnel policy handbooks and the assistance with administering those policies once they're in place. Another major piece of our time is taken in writing job descriptions and preparing those for county government. And we'll talk a little bit about that today and how they're used. One of the tough pieces of managing in the county government atmosphere is that county government in Indiana is kind of like herding cats. We've got a lot of different moving parts, a lot of different offices, a lot of different jobs, sometimes umpteen different policies, sometimes all kinds of interpretations, all kinds of backgrounds that people bring to county government. So it's often difficult to try to put into place a standard personnel policy, and then secondly, to maintain it and to administer that policy. So you get varied views and opinions, and a lot of this gets filtered in the way of, how can I take care of this employee or how can I punish that one? I come into office and all of a sudden I've come into all this wisdom between Election Day and January the 1st, and I'm going to change the world, and everything my predecessor did was bad. Everything I'm going to do is going to be to correct that, and we're off and running, and I'm going to hire all my friends and relatives to help me do that. Well, there's a lot of restrictions in terms of how newly elected officials coming to office, some of the things they can do and cannot do. And I want to make this as interactive as possible. Your questions are appreciated, and we'll do our best to try to address specific questions. But I do want to spend a little bit of time talking about the importance of personnel policies and job descriptions and how they're used. Oftentimes, we can develop policies. It's not easy, but the hard part is administering the policies. We don't get phone calls from elected officials saying, all of our employees showed up to work today, they had a great day, we didn't have any problems. We don't get those calls. We get the calls when it's usually the county attorney, county auditor, or a commissioner saying, you're not going to believe what our dumbass sheriff did today. Or fill in the blanks. It can be any number of elected officials, or the black robe guys. None of these policies apply to them, so you can't tell them what to do. So those are the kinds of issues that we often hear, and they involve things from discipline to wages to back pay to family and medical leave. And Addie's going to spend a little time at the end of the day providing you with some pointers on at least do's and don'ts in processing FMLA requests and dealing with the FMLA. It's not as easy as we sometimes think. There are timetables. There are certain things that we have to do according to the federal government. They interplay with your own policies. How do your leave policies interplay with the FMLA? How do we count time? Those kinds of things. In terms of her work with a number of counties right now, whenever there's an FMLA request, it comes to her desk. And she works with the auditor's offices or the commissioner's offices in processing those FMLA cases, so that letters go out on time, they're well documented, they use your job descriptions to support medical certifications that may be requested for fitness for duty evaluations and a number of things. So there's a lot of interplay between the policies, the procedures, and the various forms. So it's one thing to have a policy, but the policy can't just sit on a shelf and collect dust. It should be a working document. It should be up to date. It should be accurate. All the things that Tim mentioned in his presentation today, and I think a little bit more. Got a question last summer from a county auditor. It said, I've got some money in my budget for consulting. I have 2 questions. Can I pay you to answer those 2 questions? I mean, ask a consultant if they will answer questions for money. Certainly. What are the questions? Well, the first question is, do employees need to sign the personnel policy handbook? Now, the short answer, yes, doesn't get much in the way of fees. But the answer is yes. Well, we've got some county commissioners who are out here telling these employees that they don't need to sign the handbook. What? They don't need to sign the handbook? No, because if they sign it, they're going to have to be held accountable to it. You want to go, duh? So a bit of research and going through the Indiana codes, going to the SHRM websites, going to other places, the importance of employees signing the handbook, document it. How are we going to hold people accountable to our policies? These are our policies. Is it just a suggestion, or do we want to actually communicate that these are the rules of the road for operating within our county? Yes or no? Yes. So the other question was to do with almost the same thing about giving notice to meetings and, should it be a secret or should we, it's just like, it was like walking back in time. And I'm thinking, it is vital that we document everything we do anymore in the way of personnel policies and relationships, particularly as it relates to the personnel policies that we have in our handbooks, as well as what we're going to hold employees accountable to, and then how they interact with things like the FMLA, the ADA, our sexual harassment policies and the like. So we're going to talk a little bit about that today. The question earlier about the employees refusing or not signing the handbook, what can we do? They're not going to do it. I think you can take it a couple of steps further. And I've seen this happen before where, well, they won't sign it. And this will happen with other things too. Well, they won't sign this disciplinary notice. They won't sign the handbook. They won't sign their job description. Well, we can always mail it to their home address, certified mail, and we get a signature back, and that will suffice. Like Tim said, put something in the file. This is a performance issue. If people are not signing documents to show that they've received it, it's a receipt. It's nothing more. Can you imagine going and getting a loan at the bank and not having to sign anything? Well, I'm not going to sign anything. I might have to pay it back. Everything we do in life, we have to sign and verify and certify that we received it. So I think that's one thing you can do. Another thing that we do after going through a process of updating and finishing a personnel policy is to have training with the elected officials and supervisors and go through the policies with them directly so that they understand their role in the administration of the policies. Secondly, we put together a little quiz over questions taken directly out of the personnel policy for them to take back to their employees, and when they receive the new handbook, to give them the quiz that goes with it. It's not pass-fail. It is just go through the handbook and note on, we can't come to work drunk. It says that on page, 37. Okay. That becomes another important document later on, where we've also said we didn't just ask for an employee acknowledgement of the policy. We also gave a quiz, and we went through 20 questions that they had to go locate the answers to in the policy and jot down the answers. And then we keep a copy of that, and we give it, and we put it in their personnel file. So again, in the event down the road that we're dealing with the problem kids, we don't deal with the 95% that come to work, do a good job. We're dealing with the ones that become problems down the road. Look, this is the acknowledgement form. This is the quiz that employee, yes, they did have a copy. Did they read every page of that policy, and can we verify that? No, but we don't have to sit there and read it to them. Although I think it is important for elected officials and department heads from time to time to take the policy and take sections of it and sit down with their employees on a Friday morning or afternoon and go through certain sections and reinforce the idea that, these are the policies and these are how they work. 9 times out of 10, the employees are interested in two things: the salary administration section and the leave section. How many vacation days do we get? How many personal days do we get? How many sick days? The rest of it kind of falls off. But the rest of it is equally important, particularly when it comes to disciplinary matters, when it comes to our hiring and recruitment processes, and it comes to making sure that our jobs are properly classified in terms of the FLSA and whether or not we're paying overtime properly. All those things do come into play, and the elected officials and department heads need to have a clear understanding of how that works. Now, I mentioned we've worked with over 60 counties. Nearly every one of those counties, we have developed job descriptions for those counties. So as a resource, if you're not one of those counties that we've worked it with, we do that, and we do it as a project. You assign it to one person in your county today, it will not be done 3 years from now. It is not just pulling things here and yon. It is not just taking the Jasper County policy or job descriptions and making it your own in another county. There's counties the size of Allen County and Tippecanoe. Their job descriptions are far more specialized than you'll find in the smaller counties. So it's important that your job descriptions reflect your jobs and that they are assignments that are actually made to your employees. And we go through that process of engaging the employees and the department heads on the front end. Right now, we're working with Vigo and White County. Vigo, I don't know, 700 or 800 job descriptions probably are being written for them. Think about that in terms of signing that to one person who's never written a job description. We have 3 or 4 people who do this every day, and they understand county government and how that works. The process starts with job questionnaires that are blanketed out to every office and department to give to their employees. They put down a list of their duties. They check on that questionnaire the qualifications that are required to perform those duties. There has to be a connection between the two. You cannot request that somebody have a PhD in accounting and be the treasurer, deputy treasurer. It doesn't match. I mean, it's maybe nice to have a CPA, and they may be doing a, good service to the county for having that, but that is an overinflated qualification for that particular job. So the employees do participate. They sign off on the questionnaire. They sign off. Their department head does to ensure that they've accurately reported. Now, sometimes there's things in there that are not consistent. Well, the department head, guess what? They're the decider. They actually decide what that job entails. So it's often a good place to say, you don't do this. Linda has been assigned this duty, not you. And that is not going to be a part of your description. From that point on, the questionnaire and any existing job descriptions come to us. We write the job description in a draft form, goes back out to everybody with an attachment, almost like the proofs when you get wedding pictures. You like them or not, and you sign them. So there's no confusion over this whole process. So the department heads and the elected officials and the employees sign off on the draft. Is it accurate or not? If not, add to it. What are the changes that need to be made to make it accurate? Sign and date it. At that point, it becomes a final working document that eventually becomes an adopted set of descriptions. And I can't emphasize strongly enough that the descriptions in your county not be in this super secret cabinet held in your office, but they need to be out there and published and adopted as the official job descriptions, excuse me, of the county. Now, the county council in their statutes have provisions for establishing job descriptions and classifications, and oftentimes that's related to the amount of pay that an employee will have if they tie compensation to the descriptions. You don't have to do that, but you need to get those descriptions officially adopted as the job descriptions of your office or department. Again, we don't want to question down the road on, well, I didn't see that job description. It's got a bunch of stuff in it that I don't do. No, this is the job description that was adopted, and then have a process for updating those descriptions as they need updating through time. And I know that the Tippecanoe and Kosciuszko and a number of other counties, they regularly go through this process of updating. So it's not just something you do once and forget about, but you need to reflect current dates on your job descriptions at least every couple of years, and to be able to show that these are accurate, these are reliable, and these are the job descriptions we use. Now, the job description should provide a number of things besides just duties and what you're holding your employees responsible for. They ought to include things like you need to follow the personnel policies that are adopted by the county. So you include that as a job requirement. It ought to have statements regarding the Americans with Disabilities Act. It ought to have a statement on there about whether the job is non-exempt or exempt under the Fair Labor Standards Act, and whether or not the employees that are holding those positions are subject to the overtime requirements of FLSA. So this thing kind of goes full circle. Job description, non-exempt, personnel policy. There should be an overtime policy that says exempt, non-exempt employees are treated in a certain way. So there's this connection between the policies and the job description and the employee. The employee signs their job description. They also sign the personnel policy. So you're tying and linking all this together, and that becomes your HR infrastructure, if you will, in how you are administering and you have the ability to demonstrate that you are following your policies. And you can demonstrate that time and again. In the handout, I provided you with what we use it's on about page 3. Well, it's page 1. If you get beyond the cover sheets and the bios, there's a personnel policy review form. When we look at updating policies, this is our internal form. This is what we use to identify those areas where the county has a policy, or it'll also show where a policy doesn't exist, and we'll have ability to track that, and we'll also be able to have a comment to either this needs to be revised, it needs to be added, so that each policy is covered, and at the same time we'll have an interactive discussion with the county officials to discuss how you want your policy to read. I'm not really suggesting that you call up Kosciuszko County and have Ron Robinson send you their policy and just take it into your commissioners, take Kosciuszko off and put your name on it. It won't work. They have certain things that are unique to them that aren't going to necessarily apply to you, and things that you may not want in their policy. There may be some other policies that are unique to your county that you want added. So I think that's one of the flaws in just trying to steal policies from other counties. We're traveling to another county tomorrow, and Addie was commenting to me yesterday, did we do their policy before? I said, no. He says, boy, there's a lot of sections in there that look like some of the policies we do. And I said, well, I guess that's a compliment. So that happens. This checklist is designed to group like policies with one another. So in chapter 1, you're looking at things like your introductory statements, exceptions, special conditions. Well, what do you mean? I think right off the bat, we need to look at those exceptions. In certain county employees, there are exceptions. Exceptions like the merit employees in the sheriff's department. Now, there are some policies that are in merit law for sheriff's deputies that don't apply to everyone else. You need to recognize that in your policy up front. But then in where the sheriff's merit policy doesn't cover a particular policy, then the handbook policy prevails. So there's interplay between those documents. And sometimes sheriffs get a little carried away with some of the policies they put in those SOPs that may not necessarily be grounded in Indiana code. For example, one sheriff who had in his policy 8 weeks of vacation for all the deputies. Had the merit board adopt it, hey, that's great, that's cool. Well, the rest of the county employees maxed out at 3 weeks vacation. Once the commissioners and the council and the auditor and the county attorney found out about this, they had a cat. Nobody knew this. Well, the merit board, yeah, it's the way we've always done it. And can't take it away from them now. Just the way we do it around here. Where do you get that authority? Well, I'm the sheriff. I'm the constitutional officer. Yes, ma'am.
Along that line, I have a question. We have, in the past couple of years, gotten, and this is a nightmare for me because I do payroll and I'm the, by default, HR person because we don't really have one. We have 7 different handbooks for one county, depending on what department you work in. And I understand that some departments differ. We have the 24/7 ones, we have the ones that aren't. Some get overtime, some do not. She's laughing. Now,
She does it in her county.
I'm assuming everybody here has to deal with comp time.
The crack cocaine of local government. Yeah. Well,
Okay. Now, my question is, over a period of time, these handbooks, I realize by definition, some departments have to have different rules. But when it comes to what constitutes time worked and calculating overtime and how overtime is paid at what rate and whether or not you get paid for call-outs and how many hours, they're all different. We've got one department that gets paid, if it's a holiday, they get straight pay. If they have to work it, they get straight pay and time and a half. So that's 2.5 times regular rate. Another department gets straight time, and if they have to work it, just straight time. Can one employer do that when they're all employed by the same entity? Make differences? Now, I brought it to their attention that we had 2 departments that comp time was counted as time worked. rest of the departments weren't allowed to do that. Each individual, we have comp time, earned leave, vacation, holiday, and regular, okay? One department, everything counted as time work for overtime. One department, everything but comp time is counted. In another department, earned leave, comp time, and vacation did, but anything else did not count. Is that legal? And it drives me crazy. I am constantly going through these handbooks trying to see how does this department handle it. It seems not right to me,
I think we all feel your pain.
but you're not going to help me.
Yeah. No, I think a lot of us in here have experienced exactly what you've just described. On the face of it, I think there's a lot of potential for discriminatory complaints coming out of that policy, where you have certain groups of people treated better than you have groups of other people. Okay, and I think that kind of the division line is between the jobs in the courthouse that are principally concentrated with females compared to some of the other departments like highway and sheriffs that are male-dominated positions. And there's often this conflict and this merging of these policies that are a little bit different. And I think when you have a group of people, particularly a protected class like women, who are treated less than you do the men, I think you've got a problem. Secondly, to have 7 handbooks in county government is just, it's mind-boggling. Now, we did this in Randolph County. They had a bunch of them floating around. We got them all consolidated into one. But then the comment you hear, this thing's 85 pages long. Well, no crap. You know? You've got all these different policies, sure it is, but when it comes down to definitions, I really think you need to define in the policy, particularly in what we call salary administration in Chapter 3, we need to define what the overtime policy is, including comp time, and how it's going to be applied no matter what. Now, can you have different schedules? Yes, you can. There are 2 jobs in your county that allow for counting overtime differently than all the others. No, there's only 2. Merit sheriff deputies and correction officers in the jail. They can be put on, under the Fair Labor Standards Act, what they call the 7K exemption. The 7K exemption says that you can start at 7 days, 14, 21, 28, those increments, or anywhere in between 7 and on up. Instead of a work week for all the other employees in 7 days, after 7 you got to pay time and a half. Those guys, you can go up to 28 days and you don't owe overtime until after they've worked 171 hours. It's a longer period, and it allows for this fluctuation of scheduling for those kinds of jobs that are 24/7. But there's only 2 jobs like that. Now, sometimes people like to toss in the dispatchers. Can't do it. They're not considered, quote, law enforcement for the purposes of calculating overtime. We met with county clients yesterday, and we're doing a self-audit of the FLSA because they have these very issues that you just spoke of, where we've been counting comp time one way in one department, and we got it going another way in another department, actual hours worked versus not. So no, you do need to have a consistent policy. You can collapse those 7 policies into one. No more, I would say no more than 3.
I thought 2, one for the 24/7 and the odd shifts, and, I think you could probably put everybody over in with the jailers and the merit board with some exceptions. And then the ones that don't get just goes on, and EMS, you've got, they're everywhere.
Yeah, you could.
I know you said 85 pages, but try reading 7 that are 50 pages or 45.
Oh, exactly, exactly. No, you can get those collapsed, but then there's other policies like the family and medical leave. That policy ought to be the same whether you work in the recorder's office or you work in the sheriff's department or you work in the highway or any other county job. FMLA ought to be administered the same throughout the county. And we shouldn't have the 7 or 8 FMLA policies. We should have one. And all these elected officials need to understand how it works.
In regards to FMLA, we're from the same county, I'm the auditor, and this is and when we were sitting in our office talking about FMLA situations, we had a very tragic thing happen at one of the children of our one of the court employees, and actually he was lost an arm in a wreck on Christmas Day. And so the judge was very, very sympathetic to this man and very compassionate about his worker and also the situation. And of course, FMLA, it was Christmas Day, we had New Year's. She started taking FMLA Christmas, the day after Christmas. He's about 6'2", and whenever he comes off the bench and he swoops into my office with his big black robe on, he was kind of formidable. But anyway, we were sitting in there, and he said, when I sign a time card, he's an executive branch commissioner, rules, handbooks of this county does not apply to me. When I sign a time card, that person's getting paid,
Even if it's wrong.
even if it don't. And I said,
Against
well,
FMLA.
I said, I'm talking about federal law here, not, not county policy. And I said, well, my name and the treasurer's name's on a check, and it's a county employee. I'm on the line. He said, well, they have no jurisdiction over me. So at that particular point in time, I got online, I did some research, and I found out that if you take we have hours worked, or what your county considers to be hours worked in a week that you start at FMLA, and there's a holiday that you can pay that first one holiday. So our consultant decided that you couldn't really work the wire. She took our annual leave, which we consider equal to hours worked. So that she logged out of the hours that we on our leave, so we were able to go ahead and do it, so the judge thought we won, and we were able to comply with the law. Because what I had done is, in essence, had told her to put an earned leave day in for that holiday pay before we realized that she had logged out the earned leave to pay that. So, I mean, we did this continually with the court system. They come down and say, I said it's this way, I signed off on it, you don't have any control over me. We're a totally separate branch, and there's no way the executive's gonna tell the judicial what to do.
This has never come up at the AIC training in the past.
I think it's gonna be our own little state or something.
Yeah. I didn't bring my county fairy tale with me this morning, but
If you wave a magic wand and make all
anyway, all that fairy dust. Well, there's a number of issues that you brought up. One of which, back to the FMLA, you need to have a policy that specifically says how all your paid leave will be used or not used during the FMLA period. Now, there's not too many choices in the FMLA that are really up to the employer, but this is one of them. And that is, we can require that an employee who's on FMLA use their sick leave, their vacation leave, their personal days, and their paid holidays while they're on FMLA. And we can require them to use all of it during their FMLA. Even vacation. You can't. Now, I said you can, you may. Now, most employers require the use of the paid sick time. That's what it's for. You don't hang on to it when you're on FMLA. So most employers will say you shall use your paid sick time on FMLA. Some employers go ahead and put them in order. After you've run out of sick time, if you got any personal days, boom, you got to use those. If you got any vacation, boom, you got to use those. And they put them in order in terms of how they're going to be tapped. Other counties, other people have said, no, look, if Joe or Linda want to hang on to their vacation, we won't mandate that we'll say you may use your vacation if you elect to, but you don't have to. So if you go on FMLA the first 3 months of the year, whenever, and you've already promised your bride you're going to take her on a cruise in the fall, and then you burn up all your vacation time, you're gonna need more FMLA for when you get whacked over the head, for that deal. So for that reason, you can say, look, if you want to hang on to your paid vacation time, fine, but the time's going to be unpaid while you're gone. Okay, that's one thing that needs to be explicitly laid out in your FMLA policy, is the treatment of your paid leave time. That and how you count FMLA. When does the clock start? You've got a couple of choices. One choice is, well, this is a choice if you don't have an FMLA policy, because the Department of Labor will say, here's your choice. If you didn't elect to decide, here's what you're going to do. It's going to be on a calendar year. So every employee's got 12 weeks of FMLA every calendar year, which theoretically means that Joe or Linda could start FMLA in October, run 12 weeks, and start another 12 weeks in January and put 6 months together. Most employers don't like that. Most employers elect to have the FMLA on a 12-month rolling period, which means if I go on FMLA on March 1st and I use my 12 weeks, I'm not eligible for another 12 weeks until the calendar rolls around 12 months to March 1st again. Then I'm eligible for 12 more weeks. So, and it's always rolling. I don't need it March 1st of the next year. Let's say it's August 3rd, I need it. Then it rolls. August 3rd becomes the 12-month period, and it continues to roll like that. But those are the two things you really need to lay out in your in your FMLA policy. I guess the third one would be the medical certifications and how all that's going to work, and making sure you have a policy for fitness for duty evaluations, things like that, if you want to do them. The second piece of your question really goes at the Fair Labor Standards Act, which a number of items under Chapter 3 in the Salary Administration are directly related to compliance with the FMLA or FLSA. You need to establish a normal work week under the FLSA. When it starts on Monday, ends on Sunday, or whatever 7-day period you want, that's your normal work week for measurement purposes. Measurement meaning if you work over 40 hours in that 7-day period, then any time after that is time and a half if you're in a non-exempt position. You need to set out the work hours. And again, this I think addresses some of the issues that you're talking about, and I think that we see almost daily. What are the work hours? Is the lunch period, is it paid or non-paid? Several years ago, Madison County got an audit by the Department of Labor, and, well, it went on for about 3 years. It started with 6 employees who worked full-time at the jail, and then they worked part-time in community corrections as security officers in community corrections. Well, they were not bringing their time together, and they weren't being paid time and a half. And the county tried to argue, hey, these are two separate entities. Back to, these are under the courts and these are the sheriff. They twain shall not meet. So we don't know anything. No, you're a county employer. Madison County is the employer. That's who writes your check, whether you're in the sheriff's department or whether you're in community corrections. You've got to bring the time together and figure the overtime rate based upon the combined number of hours. Oh, we didn't know that. Well, you do now. She didn't stop there. Unfortunately, she didn't stop there. I don't think there's compliance throughout the county. I'm going to go through and have every elected official, every department head reconstruct their time records for a 3-year period for all their current and former employees who were working at that time. I just want to see if these overtime calculations are being made properly. Of course, like the IRS, they're going to find a technical violation. They're going to find one in every county around if you take a fine-tooth comb to the FLSA and what your practices are. And she did. And we got remarks, and the commissioners and the council hired me to coordinate the response back to the government, kind of filtering through the grief and anger of all these elected officials who didn't want somebody intruding in their office. I'm an elected official. You can't tell me what to do. I mean, that statement was made. And the courts and the judges one day, we're the judiciary. You can't tell us what to do. I'll get a federal subpoena and I'll show you. If that's what you want to do, well, I guess not. What do we need to do to comply? And actually, that brought about some timekeeping. It brought about some work hours, and it brought about overtime policies that were consistent throughout the county. So in one way, I think it had a benefit overall, because some of these other people who've never been through this, it's just fairy dust, fairy dust, fairy dust, and auditor, do what I tell you to do, and I am this and that and the other, and you are not. Well, the fact of the matter is, the Fair Labor Standards Act sets out the rules for timekeeping. They're not suggestions. This isn't a guideline. These, in our policies now, we just stick that right in the policy. This is what you have to do. We're not putting these in there because the commissioners are telling us to, or the auditor wants to make your life miserable, or any other reason. We're putting them in there because we want to ensure that we are compliant with the Fair Labor Standards Act. Whether we're in the courts or the prosecutor, the sheriff's department, wherever, this is a liability issue. I wrote down a number when I was sitting back here listening to Tim. $562,000. This is a lot of money. That's a pending case right now under the FLSA in this state in one county for 6 workers over their claim that they're due pay because they're not classified properly. We kind of disagree with that, but nonetheless, the job description is going to be key before the judge in determining whether or not they're in supervisory jobs that do not require overtime. So full circle, back to the job descriptions, they need to set out the work hours, they need to set out the FLSA status, and they need to have that signature of every employee that is working under that job. So that becomes your first line of defense when you get into these complaints. Absent that, the Department of Labor or a court will take an employee's log of hours. I worked during my lunch hour every day for 20 years, and you owe me 10 jillion bucks. What? Who allowed you to do? Nobody said I couldn't. You know, I did. And this is my record. County doesn't have a record. Whose record are they going to take? I mean, It boils down to that. I don't know why. I don't know why in Indiana county government this is so complicated. Every other business and organization you think of, we keep track of time. You know, I was lucky to take my bride to Mexico for a couple weeks this winter. We were sitting there having breakfast one day, and I looked down the corner of my eye. This restaurant, there's a time clock with employee cards. There's a novel idea. Wow. And I think they talk about Mexico being behind the United States. I mean, geez, you don't see that in all these counties around, time clock. But I think we have to have conversations with people that explain the importance of the policies, how they relate to them, and what the liability is. Because these Fair Labor Standards Act back pay claims can be huge. That Madison County thing, this was 11 years ago or so, that was well over $600,000 in back pay. Now, if it had not been the Department of Labor, you would have had double that with liquidated damages if it had been in a court, plus the attorney's fees. So you'd be well up $1.5 million, close to $2 million. And oftentimes, well, as Tim would tell you, these things aren't covered under your insurance policy. Wage claims are not covered. He'll say we're not going to cover somebody and we're not keeping proper records on payroll. So otherwise, we just have every Tom, Dick, and Harry. Hey, you owe me money. The insurance company will pay it. Here, write a check. Doesn't work that way. But everything on this checklist under salary administration, virtually everything, has to do with how we track time and what our requirements are under the FLSA. And I guess I can't emphasize that enough. I'm going to back up into the employment policies because this question comes up frequently. You need to have or spell out what your recruitment and hiring process is, and we certainly highly recommend that you post positions when they become vacant. Well, I already know who will want to hire. Why do I have to go through all that? We've never done it like that before, and you're not the boss of me, and you can't make me do it. County government is an equal opportunity employer. We state that. These are public jobs. They're paid for by taxpayers. Too often the taxpayers think they're working in this closed system. You can't get a job unless you know somebody down at the courthouse. So they don't even apply. We need to be able to demonstrate, again, that we are equal opportunities employers. When we have job openings, we post the job and we let the public know. They can make application. Other employees can make application to that posted position until it's filled. Again, the rub is you're trying to tell me what to do. I'm an elected official. I can hire anybody I want. No, we're not telling you what to do. We're saying you need to go through a process. It needs to be open, and it needs to be non-discriminatory so that people can make application. If they think they're qualified, they can apply. We're not telling you who to hire, but we say, here's a stack of applicants that applied for the job. Go through them, find the people that you think best meets your qualifications, pull some of those in, conduct interviews, ask the same questions of each one. You make the selection. That's simple enough. We can document that, show it, so that, again, we're not going to be hit with, you didn't hire me because I was black, because I was a woman, because I was a Democrat or a Republican or whatever it may be, old. You don't want that. You want to have a transparent hiring process so that you can demonstrate. And I know oftentimes you get a lot of resistance to that. Well, I already know who I want in there. Well, work with us. Go through the process. Do a background check. You may find that some of these people you want to hire aren't really people you want to hire. And your question on drugs and screening, I think for all county jobs, that we do initial drug screens for all new hires. All of them. You never know. And people who are involved with money and other things outside of law enforcement, I think we don't know if they have a serious drug problem or a gambling problem or whatever problem they may have, because we may not want to put them into some of these positions we have in county government. And I'm not going to go through the list of about 20 people who've made the front page in the last 18 months in this state.
What about election workers?
No, election workers, probably not. I don't know, the real seasonal or sporadic type worker, I don't think we're going to do every precinct committeeman and all the, no, but I would do the people who are going to be lifeguards at swimming pool. Those kinds of jobs I would. So, but that's a call of the employer in terms of, what you want to do.
Quick question. Typically, the commissioners adopt or take some kind of an action on setting a policy. But, if there are components that the council usually handles or their legal obligations like wages and salary, would the council control that part of it and adopt that part of the policy?
Does everybody hear the question? The commissioners normally adopt the policy, but there's certain pieces of it that apply to the council. When we work with counties, I like to get a small group together that includes commissioners and council, auditor, HR person, if there's one there, county attorney, to work together to develop policy. And at the end, I think either both groups officially adopt the policy or the county council adopts those sections of the policy that apply to the council as far as compensation goes. And I take it as a council to the step of putting in the salary ordinance, reference to the county policy is being adopted by reference for purposes of compensation, even so far as to include the paid leave policies. Why? Because that becomes a term and condition of pay under the ordinance. It's something that the auditor can hold up and say, no, Sheriff, you don't get 8 weeks of vacation. This is what we're paying for. Paid leave is compensation, and the council does have the authority to set the compensation policies. So compensation is not only the salary that you're noting in that salary ordinance, but is also discussing those paid leave policies that are there. Another step I would go in that salary ordinance would also be designated, having another column, FLSA status, exempt, non-exempt, and specifically lining out those positions that are eligible for overtime versus those that are not. Again, this trying to build this network and pulling policy and compensation practices together. And I think where councils and commissioners work well together, this is it. I think it heads off a lot of the problems that we have where councils and commissioners don't work so well together. There's a number of items I've listed here: common policy mistakes, not having a policy, never updating the policy, Borrowing, a policy from your neighbor, not defining important terms, full-time, part-time, seasonal, temporary, and this is particularly important now with the Affordable Care Act and who becomes eligible for health insurance. Work week, work hours, I've talked about the overtime policies, methods for calculating overtime. Yeah, do we count the time worked on a holiday as actual hours worked for overtime purposes or not? Do we count the vacation as time worked or not? We don't have to. If I'm on a 5 days, 8 hours a day, and I work on Monday, and I take off on Tuesday for vacation, and I work 10 hours on Wednesday, and 8 on Thursday, and 8 on Friday, am I due time and a half for those 2 hours on Tuesday? The answer is no, I'm not. I didn't actually physically work 40 hours. Now, a lot of counties count that time as time work for the purposes. Does the Department of Labor care? God, no, they don't care. You're going beyond what the minimum requirement is. They set the floor, not the ceiling, so they don't care. It's like, you can pay more than the minimum wage. They're happy with that, but you don't have to. But you do need to spell out whether or not the time's going to be counted in that threshold or not. You need to define your benefits eligibility. You need to define immediate family for bereavement and other policies. Not having a family and medical leave policy is kind of a no-no. Not having a sexual harassment policy is in violation of the Civil Rights Act. Not having a drug-free work policy, a no retaliation policy, an equal opportunity statement policy, or a complaint process. There's a difference between a complaint process and a grievance process. I think you need to have some kind of problem resolution policy that affords the opportunity for counties to settle their problems internally. So you can bring a complaint and have it dealt with, but not a grievance policy that, like a union contract that has all these various steps, and you miss one, and you go back to square one, and get a free get out of jail card if you're the employee. No, it's not a guarantee, but it is a process. If you have a problem with the way the administration handled your FMLA leave, well, here's the way you bring that forward so we can talk about it and resolve it, as opposed to encouraging you to go out and file a lawsuit against the county. So in that sense, I think that can be beneficial. As Tim was talking this morning, you don't want those policies that creates a contract or any legal rights. No, you don't want to say that you're going to get through your probationary period and you've got a job forever. But I think you may want a policy that here's the introductory period, and we use this to evaluate whether or not that you're going to work out or not. And we may extend it if you're not. There's nothing wrong with that. Not adopting the policy and giving employees notice. We've got, again, it needs to go on record. Somebody adopted it on a certain date. We've seen cases where it was never adopted. We don't know what's going on. We've got these 7 policies rolling around. We don't even know what's in effect. You'll have policies that are being drug out by employees. They were handed 10 years ago, and you don't know whether or not they're still accurate or if they're still up to date. And you don't want to abandon your at-will policy. I'm going to skip the hypothetical. Yeah.
I mean, FMLA, is that something that has to be done 12 weeks in a row, or is it based on days or hours?
Everybody hear the question? FMLA, does it have to be 12 in a row, or can it be hour? It doesn't have to be 12 weeks in a row.
Okay.
You have 12 weeks, and it can be taken intermittently. It can be taken in increments as small as an hour, okay? So somebody who is going for treatments every week, They work 4 days, but that one day or half a day they're going for treatments, then it's taken in hours. And if you're going to have somebody on FMLA, then you almost, and they're going to be doing it intermittently, you ought to just convert their time to hours. And how do you do that? Well, what's going to be the normal work schedule for the next 12 weeks? How many hours would I be working in the next 12 weeks? That becomes the number of hours that you're eligible for intermittent leave, or how it's going to be deducted down. You may not even exhaust it after a year goes by. You'll get another deposit of time, but that's how you would do that. So no, you don't have to use it. In fact, why don't I get Addie up here to talk about the FMLA, and if we have time, we'll go back on this FLSA quiz that I mentioned earlier. But I think much of what I've covered in our discussion here this morning, many of the things on that quiz have been mentioned.
All right, the FMLA, just a quick overview. The FMLA entitles employees, eligible employees, to unpaid leave with job protection for family and medical reasons. The FMLA provides for 12 weeks of leave during a 12-month period, and as Kent stated, that can be calculated different ways depending on your policy. Covered reasons include the birth of a child and the care for a child for up to that first year, the placement of a child with an employee for adoption or foster care, and to care for that child for a 1-year period, to care for an employee's spouse, child, or parent who has a serious health condition, for a serious health condition that the employee has for their own personal reasons, any qualifying exigency rising out of the fact of an employee's spouse, son, daughter, or parent who is a covered military member that is going on active duty. And the exception to the 12 weeks is the 26 weeks of leave that is allowed for in a single 12-month period for those who are a service member who is injured on duty, and that it has to be an eligible employee, and they have to be related by spouse, daughter, parent, or next of kin. So that's the only exception to the 12-week FMLA requirement. Below spells out the basic FMLA process, and this applies to employees who are on have a serious health condition, or if there is a family member. These are the steps that you would go through. First, you have to you begin with either the employee requests FMLA leave, or the employer acquires knowledge that the employee's leave may be FMLA qualifying. We don't have to wait for the employee to request it if we have knowledge. What kind of knowledge? The triggers. If an employee is admitted to the hospital, that's an automatic trigger. You want to start the paperwork. If an employee is injured on the job and is sent to see the workers' comp, even if they might be released the next day and come back, but we don't know, we want to start the process. And the other main triggers for department heads and elected officials is if an employee has been off work on sick leave for 3 consecutive days. If they don't come back that 4th day, that is a trigger. You want to start that paperwork if it's something that might be qualifying.
Is this for full-time employees or part-time also?
The eligible employees would be someone that has worked for 12 months and has worked at least 1,250 hours. So that you lead right into the next step. You're going to, once they request or you have knowledge, you're going to determine whether or not the employee is eligible. So you look at if they meet those 2 qualifications, and also have they used FMLA? Do they have any time left? On intermittent basis, I mean, if it's something new that comes up, you want to make sure, okay, did they have time left from the last FMLA they were on? Or do we have to wait? Are they not eligible until June for any more FMLA? We have to look at those items. And the county has 5 days to notify the employee of their eligibility to take FMLA. So it is very important that we respond quickly to a request or respond quickly if we have knowledge that this might be qualifying. And we want to inform the employee in writing whether or not they are eligible. And the Department of Labor has great forms for these notifications, and we highly recommend that you use those. I mean, you can send out other written letters, but this makes it a little easier. If the employee is eligible, we want to send them a certification form, and this is going to see if the condition is FMLA qualifying. And the employee has 15 days, 15 calendar days, to complete that and return it back to you. So they are on a timetable as well. And there are 2 different forms. Again, on the Department of Labor, there's a separate form for the employee's serious health condition, or if it's a family member that they're applying for. There are 2 different forms that you would use. So step 3, you've sent the form, now the employee has returned it to you. You're going to review the form first to see if it's complete or incomplete. If it's incomplete, you're going to list the reasons why, and you're going to submit it back to the employee, tell them what's deficient, what's missing, and the employee then has to fix the deficiencies, and they have 7 days to do that and get it back to you. If it's complete, or when you get the information completed, you want to review it to see if the certification, if the requested reason is or is not covered by FMLA. Like the reasons we listed before, make sure it's a qualifying reason. A couple ones that we've received here in the last few months, one was requesting for cosmetic surgery. The FMLA does not cover elective cosmetic surgery. However, if there were complications that arise from and put this employee in the hospital for complications, that would be qualifying. Employee requested to be off on FMLA to care for her ill sister. Sisters were not covered under the FMLA, so that's not qualifying. So we want to make sure that we've checked out and it does qualify before we notify the employee. If the employee does qualify, we are going to notify them in writing that yes, your leave qualifies, and we're going to start counting the time against your 12-week entitlement. We're also going to notify them at this time whether or not that they were going to require a fitness for duty evaluation certification when they come back. I recommend that you do this consistently across the board. You don't pick and choose which illnesses or which employees you're going to require this. That way it's consistent and you don't have to worry. It's just an automatic process that you do. The employer has 5 days to notify the employee that the time off is designated or is not designated as FMLA. So when we get that form back, we only have 5 days to review it and get that information back to the employee. So if the employee qualifies and we've sent the designation notice out, the next step that you have, the employer is responsible for tracking the FMLA time. And like Kent said, it can be converted to hours, and you also want to be tracking your leave time according to your policy. If you do convert it to hours, you want to deduct the leave time in the same increments. Even if the leave time normally under the policy says you have to use it in full day, you have to take a vacation in full day increments, the FMLA trumps that, and you have to allow them to take a vacation day in 1 hour increments. I recommend that about 2 to 3 weeks out of when the FMLA would end, that you send a notice to the employee in writing notifying them that their FMLA is going to end and on what date, and that you're expecting them to return on an included date. and requiring the employee to make contact with you whether or not they're going to be able to return. One, that may gives them notice that, okay, yes, my time is up, and reminding them again in the letter that the fitness for duty certification is required, and you may have to resend the form and send a job description so they can take that to their medical provider so they can be released to come back to work. So step 5, once you get that release from the medical provider that they can perform all the essential functions of the job, you're going to reinstate them back to their job with equivalent pay, equivalent benefits, and just you'll have that documentation that shows that they had the FMLA, and then that way if future FMLAs come up, you know what's been taken and that the county has complied with all the regulations. Are there any questions? Yes.
2 questions.
Okay.
Is a chiropractor considered a medical provider? And then is a nurse practitioner qualified to return a person back to duty?
I believe so. If that's who they've been seeing for the treatment, and it was communicated that it was an FMLA qualifying. But if there's a question, the county does have the option for a second medical opinion. If that comes up, those within your rights to do that. And then you can choose who that employee would go and see. A lot of times you have to get into the specialties for, if it's a heart condition and those type of things. So there might be those specialties that would constitute that. Yes?
I know that the form that we use for the fitness review, I'm assuming that we got it from Dixon. No, it's not good thing. But our fitness review form that we currently use lists how long you can stand, how much weight you can lift, whether you can bend, all the different physical attributes. It doesn't have anything in it that concerns ability to concentrate and alertness. We've got a situation right now with an employee who is on doctor prescribed medication, and it's a job where she's a 911 dispatcher. She has got to be able to be capable of making quick decisions and staying alert. We keep sending her to the doctor, and they keep releasing her because there's nothing physically wrong with her. What can we do? I mean, there needs to be something on the form stating that she is, and I don't know how you can do this, mentally capable, alert enough to continue to do this job. We're just going in circles with this.
Right, you can require mental evaluations as well. And the key, again, is the job description and sending that with the medical provider. We want to make sure that this is the responsibility, that this individual has to be able to make decisions, has to be alert to send out medical personnel. And we want to know if they're going to be able to be capable of performing these functions and responding. And you can list those specific requirements out for the medical provider to review and sign off on the individual duties. So you can modify that form for that position, or kind of create your own that then you can send and say these are the information that we're looking for and the answers.
Well, the fitness review form, is that a standardized form by the government? Do we have, is there one that has to be used?
No. Well, because it would vary according to what the job requires. Right.
Again, based on that very accurate document.
Correct.
I was going to add, sometimes you also want to send a letter and just lift out of the letter or the job description, put it in the letter. This job involves these things, focusing, being alert, working in emergency situations, those kinds of things in the letter. And we need, in order for this person to come back, they need to be released to perform all the essential functions, not just the physical ones, but all of them, so that we're not gonna let them come back to work, particularly if we think it's a public safety risk to bring them back for themselves or for the public. We've had, EMT people want to take out of the job description the ability to lift 50 pounds. I'm thinking, what? Just hop on that gurney yourself, when you're at an accident scene. So we want to make sure that all those functions are listed when we have any doubt. And it's not good enough to say highway truck driver. We need to say what that entails and whether or not this person is alert and has a clean driving record and all those kinds of things.
Yes.
You spoke earlier about county may be requiring employees to take their earned time, vacation time, personal days, sick days, et cetera. If a person has a qualified advance, say it's an adoption or something like that, and they have, say, 4 weeks or so of time earned, would we start the FMLA process first day, or do we wait until they use that time earned and then start it at that time?
You would start FMLA the first day that the leave commences. So as soon as that child is placed with them and they're off work, that's when you would trigger, even if they have the paid leave available. So you'd run them concurrently.
Just wouldn't count against their 12 weeks until they started, until they ran out of their time.
No, it would still count. Even if it's paid, it still counts against their 12 weeks. Yes?
I know you're trying to get out of here, but I have one more I have got to ask. We run our workers' comp and FMLA currently, and our policy states that you have to use time, not vacation, but all your other time if you're on FMLA. If they're on workers' comp, they're drawing a paycheck, but it's only 2/3 of what. Now, we allow them to use their time to come up to what their normal pay would be. They never want to. They want to hold on to. I mean, I've got a guy who's been off almost 6 months. He has 300 and some hours, plus his vacation that he could be drawing, but he's not. Do the FMLA, if we require under FMLA to use your accumulated time, but you're also under workers' comp, do they or do they not have to use that time?
In that case, when you're running them concurrently, the workers' comp actually trumps the FMLA, so you cannot require them to use their leave time. Now, if they request to, then they can supplement that 1/3. Right, they cannot get paid more than what they would have if they actually worked. Otherwise, there's no incentive to come back.
Okay, thank you very much.
Run through the quiz. You want to run through the quiz? Okay.
All right, last page here. Number 1, an employee eligible for FMLA is entitled to 12 weeks of paid leave for certain family and medical reasons during each calendar year. True or false? Correct, that is false. It's unpaid leave and it's 12 weeks in a 12-month period. Number 2, workers' compensation leave may count as FMLA if the reason for the absence is due to a qualifying serious illness or injury and if the employer properly notifies the employee in writing that the leave will be counted as FMLA leave. That is true. Number 3, employers are not obligated to provide FMLA leave until the employee makes a request for FMLA. False. Very good. You were listening. Number 4, employees are eligible to take FMLA leave if they have worked for their employee for at least 12 months have worked at least 1,250 hours over the previous 12 months. That is true. Number 5, an employer may require that while an employee is on FMLA leave for his or her own serious illness or injury, he or she shall not be engaged in outside employment. That is true. The only exception is that if an employee is on leave to care for a family member, that does not apply. So if they're caring for their child or their spouse, they can still work their part-time job.
Again, if they're workers' comp person told me that as long as it was light duty and they were not doing any job that was restricted by their doctor, they could work someplace else.
Well, if you have a policy in place that says they're not allowed to work while they're on FMLA for their own serious illness, then they violated the policy.
So, but is that federal? I mean, they're not allowed to work, or is that, see, that confused me, because we don't have light duty, and a lot of times the doctor will release somebody to do light duty work,
Right.
but we don't offer.
You don't have to create a position, a light duty position.
Where can they work a light duty job if we don't offer it?
I think that that would cancel out their.
I would say no. I mean, the whole purpose is if you're not able to work here, we don't want you working out here someplace else. And it's an encouragement for you to get back to work. So we don't want to run into you out here at Walmart on the weekend working a part-time job when you say you couldn't work an equally stressful physical job with the county. So I think you can enforce your outside employment policy, and you can even have that as a separate policy. You know, people that are off on whatever cannot be engaged in outside employment.
Number 6, an employer cannot require employees to use accrued paid leave such as sick, vacation, or personal days for any part of the 12 weeks of FMLA leave.
True. True.
That is false. You can require to use the paid leave
If your policy book says it.
if your policy says it. Yes. Number 7, employers must provide employees with light duty when a physician makes this stipulation for an employee returning to work after an illness or injury. You are a step ahead. That is false. Number 8, upon return from FMLA leave, an employee must be restored to his or her original job or to an equivalent job with equivalent pay, benefits, or other terms and conditions of employment. That is true. Number 9, an employer is not required to maintain group health insurance coverage for an employee on FMLA leave. That is false. The employer is required. And number 10, the FMLA does not permit employees to take leave on an intermittent basis or to work a reduced schedule, such as to care for a newborn or newly placed adopted or foster care child. That is mostly false, partially true. You can take intermittent leave when medically necessary. The only exception with the intermittent or reduced schedule, if for the newly adopted replacement of child, you have to have the employer's permission agreement. That's the only exception where the employer has to agree to that for those reasons. So, any other questions?